My son-in-law won $95 million in the Mega Millions lottery on a Tuesday night. By Thursday morning, he was standing in my living room telling me to get out of my own house. He had a lawyer with him, a man in a gray suit holding a manila envelope. The lawyer handed me a document, a formal eviction notice, printed on legal letterhead, citing Virginia Code Section 55. 1-45, the unlawful detainer statute. It said I had 30 days to vacate the property at 4012 Sycamore Lane, Fredericksburg, Virginia, my property, the house I'd built with my wife in 1993, the house where I'd raised my daughter, the house where my wife had died of lymphoma in 2019, the house where I'd been living alone for 5 years, paying every tax bill, maintaining every room, mowing every inch of the half-acre lot. My son-in-law, Brandon Hale, stood behind the lawyer with his arms crossed and a smile that cost nothing and was worth less. He was 34 years old, a former assistant manager at an auto parts store. And as of 72 hours ago, he was worth $95 million before taxes, approximately $57 million after the lump sum federal and state withholding, which in Virginia is calculated at a combined rate of roughly 37.6% for lottery winnings of that magnitude, $57 million. And the first thing he did with it was try to take my house. Arthur, Brandon said. He always called me Arthur, never Dad, never Mr. Tillman, just Arthur. Like I was a coworker he barely tolerated. This doesn't have to be complicated. Lee and I want the house. It's a great property. We're going to renovate it. You can find somewhere else. We'll even give you $50,000 for relocation. That's generous. The $50,000 for a house worth $485,000 on a half-acre lot in one of Fredericksburg's most established neighborhoods, 2 miles from the Rappahannock River and 6 minutes from downtown. A house that was paid off. A house with no mortgage. No lien, no encumbrance of any kind. He was offering me 10 cents on the dollar and calling it generous. Brandon, I said, you can't evict me from my own house. It's not your house, Arthur, it's Lee's. Her name is on the deed. Has been since your wife died. Check the county recorder's office if you don't believe me. I looked at my daughter. Leah was standing in the doorway, behind Brandon, behind the lawyer, behind the whole performance. She wasn't smiling, she wasn't frowning. She had the particular blankness of a woman who'd made a decision she couldn't undo and was watching it unfold from behind glass. Lee, I said, is this true? Is your name on the deed? She didn't answer. Brandon answered for her. We had the title transferred 6 months ago. Lee signed the quitclaim deed. It's filed with the Spotsylvania County Clerk's Office. Document number 2024 Auto 87432. The house is legally hers. And as the property owner, she has the right to determine who lives here. A quitclaim deed. If you don't know what that is, and I didn't, not fully, not until that morning, a quitclaim deed is one of the simplest and most dangerous documents in American property law. Unlike a warranty deed, which guarantees clear title, a quitclaim deed simply transfers whatever interest the signer has in a property, with no guarantees, no warranties, and no protection for the person signing. It's the document used in divorces, family transfers, and, increasingly, in elder exploitation cases where family members convince elderly homeowners to sign over their property without understanding the consequences. The National Center on Elder Abuse reports that financial exploitation is the most common form of elder abuse in the United States, affecting an estimated 1 in 10 Americans over the age of 60. Property theft through quitclaim deeds is one of the primary mechanisms. A signature on a single page can transfer a lifetime of equity in minutes. I knew none of this on that Thursday morning. I just knew that my son-in-law was standing in my living room telling me my house wasn't mine anymore. Before we go any further, thank you for being here. If this story has your attention, take a second and tell me in the comments where you're watching from today. It truly helps this channel reach more people who need to hear these stories. And a gentle reminder, while this story carries real emotions and real lessons, some names, details, and events have been fictionalized for narrative and educational purposes. Any resemblance to real individuals is coincidental. The truth behind this message is what matters. Stay with me, because what Brandon didn't know about this house is the reason he's no longer smiling. My name is Arthur Tillman. I'm 67 years old, and the house on Sycamore Lane has a history that Brandon Hale never bothered to learn. Let me take you back. I met my wife Gloria in 1985 at a church picnic in Fredericksburg. She was 23. I was 26. She was a dental hygienist with a laugh that carried across parking lots and a work ethic that would have impressed a drill sergeant. I was a surveyor for the Virginia Department of Transportation, a man who spent his days measuring land and his evenings dreaming about owning some. We married in 1987. Lee was born in 1990. And in 1993, Gloria and I bought the lot on Sycamore Lane, a half-acre of Virginia clay that nobody wanted because it sat on a slope and the previous owner had let the drainage go to ruin. We bought it for $32,000. Cash. Every penny saved from 8 years of combined income, deposited at the Spotsylvania County Clerk's office with a warranty deed that listed both our names, Arthur Raymond Tillman and Gloria Ann Tillman. Joint tenants with right of survivorship, the most common form of co-ownership for married couples, meaning that when one spouse dies, the other automatically inherits full ownership without probate. We built the house ourselves. Not metaphorically, literally. I was a surveyor. I knew land, grades, drainage, setbacks. Gloria's brother was a licensed contractor. We hired subcontractors for electrical and plumbing, but the framing, roofing, drywall, and finish work were done by us. Weekends and evenings for 14 months. Gloria hung drywall at 7 months pregnant with our second child, a son Michael, who was born in 1994 and who is relevant to this story in ways that will become clear. The house cost $87,000 to build in 1993. It was worth $485,000, a 457% increase driven by Fredericksburg's growth as a commuter hub for Washington, D.C., and the general appreciation of Virginia real estate over 3 decades. Gloria died on March 3, 2019. Non-Hodgkin lymphoma. She was 57. The disease took her in 11 months from diagnosis to death in less than a year. She spent her last weeks in our bedroom in the house we'd built, watching the dogwood trees she'd planted along the driveway bloom one final time. When Gloria died, the house transferred to me automatically through the right of survivorship clause in our joint tenancy. No probate. No court filing. No delay. The deed updated through operation of law. I filed an affidavit of survivorship with the Spotsylvania County Clerk's office, attaching Gloria's death certificate, and the property became mine alone. Arthur Raymond Tillman, sole owner. Free and clear. That was the legal reality. That was what the county records showed. That was what was true, until Brandon Hale decided it wasn't. Let me tell you about Brandon, because understanding him is essential to understanding what happened. Brandon Hale grew up in Stafford County, about 20 minutes from Fredericksburg. He was one of those men who believed he was destined for something bigger than his circumstances, a common belief, and not inherently harmful, except that Brandon's version of something bigger didn't include work. It included luck, shortcuts, the conviction that the universe owed him a break and that one day, that break would arrive. He worked at AutoZone for 6 years. Assistant manager, or $38,000 a year. Not a bad job. But Brandon talked about it like it was a prison sentence. This isn't me, he'd tell Leah. I'm meant for more. What more looked like, he could never articulate. It was a feeling, not a plan. A destination without a map. Lee met Brandon in 2018, a year before Gloria died. She was 28, working as a receptionist at a veterinary clinic. Brandon was 28, selling alternators and brake pads. They connected over what Lee later described as ambition. Though in retrospect, what she identified as ambition was actually restlessness, which is ambition's counterfeit. They married in 2020. Small ceremony. Courthouse. I paid for dinner afterward. A restaurant in downtown Fredericksburg that Brandon chose, and that cost $400 for 4 people, which was $350 more than I would have spent, but $400 less than Brandon wanted. He'd suggested a restaurant in D.C. I'd suggested we stay local. He'd looked at me with the particular expression of a man who believes his father-in-law is an obstacle rather than a family member. After the wedding, Brandon and Lee moved into an apartment in Stafford. Brandon continued at AutoZone. Lee continued at the vet clinic. They lived paycheck to paycheck, a $76,000 combined income against $3,200 a month in expenses. No savings, no investments, no financial plan. Brandon bought lottery tickets every week. The 20 a week on Mega Millions and Powerball, $1.40 a year spent on a statistical impossibility that Brandon treated as a retirement strategy. The odds of winning the Mega Millions jackpot are approximately 1 in 302. 6 million, roughly the same odds as being struck by lightning twice in the same year while holding a royal flush. On January 14, 2025, those odds collapsed. Brandon's numbers matched. All 6. The Mega Millions jackpot was 95 million. Brandon Hale, assistant manager at AutoZone, was suddenly one of the wealthiest people in Spotsylvania County. Now, here's what most people don't know about sudden lottery wealth. There's a clinical term for what happens to people who receive massive, unexpected financial windfalls. It's called sudden wealth syndrome, first described by psychologist Stephen Goldbart. The symptoms include anxiety, guilt, isolation, paranoia, and, most relevant to this story, a dramatic shift in identity. The person who wins begins to see themselves as fundamentally different from who they were before. Their relationships change. Their self-perception changes. Their sense of entitlement expands to match the size of the bank account. Brandon exhibited textbook sudden wealth syndrome within 48 hours. He quit AutoZone on Wednesday morning, walked in, told his manager he was done, and walked out without giving notice. He bought a Mercedes AMG LE that afternoon, they $115,000, paid in cash from an advance against the lottery winnings. He hired a lawyer, not a financial planner, not an investment advisor, a lawyer, because the first thing Brandon wanted to do with his money wasn't grow it. It was use it as leverage. The Virginia Lottery Commission processes jackpot claims through its headquarters in Richmond. Winners of prizes over 600 must claim in person, submit to identity verification, and choose between an annuity paid over 30 years or a lump sum payment. Brandon chose the lump sum, which for a 95 million jackpot meant a pre-tax payment of approximately $45.6 million. After federal withholding at 24% state tax at 4% plus the additional federal tax liability at the top marginal rate of 37%, his net take home was approximately $57 million. $57 million. More money than most people earn in 10 lifetimes. And Brandon's financial plan, his entire strategy for managing this generational wealth, was to hire a $15,000 lawyer to evict his father-in-law from a house worth $485,000. This is what sudden wealth syndrome does. It doesn't make you smarter. It makes you more of who you already are. And Brandon Hale had always been a man who measured his value by his ability to dominate the people around him. Before the lottery, he dominated through complaints and petty grievances. After the lottery, he dominated through lawyers and legal threats. The currency changed. The character didn't. The week between winning the lottery and showing up at my door was a masterclass in how not to handle wealth. Beyond the Mercedes and the lawyer, Brandon also put a deposit on a $4.2 million house in McLean, Virginia, a D.C. suburb where hedge fund managers and lobbyists live. He bought Leah the $28,000 Cartier bracelet. He opened a business checking account at a bank in Stafford and deposited $2 million in cash, triggering a currency transaction report, or CTR, which is automatically filed with the Financial Crimes Enforcement Network for any cash transaction over $10,000. None of this was illegal. All of it was reckless. And all of it was prelude to the moment he walked into my living room with Craig Dunlap and a manila envelope. And the first target was my house. Here's what I didn't know until the lawyer handed me that eviction notice. 6 months before the lottery win, in July 2024, Brandon had convinced Lee to add her name to my property deed through a quitclaim deed. How did this happen? How does a 67-year-old man lose ownership of his home without knowing it? It happened because I trusted my daughter, and because Brandon exploited that trust with surgical precision. In June 2024, Leah came to visit. She brought paperwork. She said it was for my estate planning, a phrase she'd never used before, a phrase that Brandon had coached her on, a phrase designed to make a legal document sound like a protective measure rather than a theft. Dad, my friend at work says you should make sure the house is set up so it passes to me without probate. Just in case something happens. It's just a formality, a simple form. She put a document in front of me. 1 page. Simple language. A quitclaim deed that added Lee Marie Hale as a joint tenant on the property at 4112 Sycamore Lane. She had a pen. She had a notary, a woman she'd brought with her. A mobile notary who charged a $25 per signature and didn't ask questions. I signed it. Because my daughter asked me to. Because she said it was for estate planning. Because I was 66 years old, And I'd been living alone for 5 years, and the loneliness had made me grateful for any attention from my children. Because I didn't read the document carefully. Because I trusted her. What I didn't know, what Leah may or may not have known, was that a quitclaim deed adding a joint tenant doesn't just give the new tenant a future interest. It gives them an immediate, present ownership stake. The moment that deed was filed with the Spotsylvania County Clerk, Lee owned half my house. And as a joint tenant, she had the legal right to sell, transfer, or leverage her interest, or, with the right lawyer, to argue that her interest was superior to mine. Brandon knew this. He'd researched it. I later learned that he'd spent weeks on legal forums and real estate websites, studying Virginia property law, understanding the mechanics of quitclaim deeds, identifying the exact vulnerability that would let him take my house with a single signature. He hadn't known about the lottery. The quitclaim deed was Plan A, get Leah's name on the property, wait for me to die or become incapacitated, and inherit the house through the joint tenancy. The lottery was Plan B, use the money to hire a lawyer and accelerate the timeline. The eviction notice was the acceleration. When Brandon's lawyer handed me the document, I didn't panic. Not because I'm brave, because I'm a surveyor. I've spent 40 years reading legal documents about property, deeds, easements, right-of-ways, boundary disputes, title searches. I know what a quitclaim deed is, I know what a joint tenancy is, and I know what an unlawful detainer action requires. I also knew something Brandon didn't, something Gloria had done in 2017, 2 years before she died, that made everything Brandon was attempting legally impossible. But I didn't tell him, not yet, because the best way to defeat a man who thinks he's won is to let him keep thinking it. I need some time, I told Brandon. 30 days, you said. 30 days. That's the law. After that, we file for forcible entry and detainer in the General District Court. You'll be removed by the sheriff's office. I understand. Brandon smiled. The lawyer closed his briefcase. They left, and I picked up the phone and called my son, Michael Tillman, born 1994, the second child. The one who doesn't come up in conversation at family dinners, because Michael and Leah haven't spoken in 4 years, not since Michael told Leah at Thanksgiving 2020 that Brandon was a con artist who's going to rob you and Dad blind. Leah had screamed at him. Brandon had stood up from the table and said, "Your brother doesn't respect our family." Michael had left. He hadn't come back. He'd been calling me every Sunday, checking in, making sure I was eating, making sure I was okay. But he'd stopped attending family events because Brandon's presence made them intolerable. Michael is an attorney, a real estate attorney. He works at a firm in Arlington that specializes in property disputes, title litigation, and the detail that matters most, elder financial exploitation cases under Virginia's Adult Protective Services Statute, VA Code Section 1603. Dad, I've been waiting for this call for 4 years. Michael said when I told him what happened. You knew. I knew Brandon was planning something. I didn't know what. But I warned you. I warned Leah. And I warned your mother? Mom knew. She always knew. And here's where the story turns. Because Gloria, my wife, the dental hygienist with the laugh that carried across parking lots, had done something in 2017 that Brandon Hale never discovered. Something that made his $95 million eviction attempt worth less than the paper it was printed on. In February 2017, 2 years before she was diagnosed with lymphoma, Gloria went to a lawyer named Helen Vasquez. Helen was, and still is, one of the most respected estate attorneys in Fredericksburg, specializing in the Uniform Trust Code as adopted by Virginia under VA Code Title 64. 2. I didn't know Gloria had gone to Helen. She didn't tell me. She made the appointment during my work hours, drove to Helen's office on Princess Anne Street, and spent 2 hours discussing our property, our family, and our future. Helen told me about the meeting after the trial, when the case was public and the attorney-client privilege had been waived by the trust's exposure in court. Your wife came in with a legal pad full of notes, Helen said. She'd been researching trusts for weeks. She'd read articles about elder property theft. She'd read cases where elderly homeowners lost their homes through quitclaim deeds, power of attorney abuse, and guardian exploitation. She was informed in a way that most clients aren't. Not like a lawyer, but like a patient who's researched her diagnosis. She knew what she was protecting against. What did she say specifically? She said, "I love my husband. I love my children. But love doesn't prevent bad decisions. I need a structure that survives bad decisions." And then she said something I'll never forget. She said, "I'm not worried about Arthur. I'm worried about whoever gets close to Arthur after I'm gone. I can't predict who that person will be. So I need to protect the house from everyone." Gloria had looked into the future and seen not a specific threat, but the shape of one. Not Brandon, she'd never met Brandon, but someone like Brandon. Someone who'd see the house as an asset and Arthur as an obstacle. Someone who'd use legal mechanisms they understood to take something they hadn't built. Helen created the irrevocable trust in a single session. The structure was elegant in its simplicity. The house was transferred from the joint tenancy into the trust. I remained the lifetime beneficiary, meaning I had the legal right to live in the house, maintain it, and use it for the remainder of my life. Michael was named successor trustee, giving him legal authority to manage the trust if I became incapacitated. And the trust itself was irrevocable, meaning that once it was created, it could not be modified, dissolved, or overridden by anyone, including me. The key provision, the one that defeated Brandon, was Section 4.2 of the trust document. No interest in the trust property may be transferred, assigned, pledged, or encumbered by any beneficiary, and no interest in the trust property shall be subject to the claims of any creditor, spouse, or family member of any beneficiary. In plain English, nobody, not me, not Leah, not Michael, not any future son-in-law or daughter-in-law, could touch the house. It was locked inside a legal structure that was designed to outlast every threat Gloria could imagine. The total cost Ithers $200. Attorney fees, filing fees, and recording fees at the Spotsylvania County Clerk's office. Fors $200 to protect $40,085 in property. That's a 25% insurance premium against catastrophic loss. Gloria would have appreciated the math. She always appreciated good math. Gloria created an irrevocable trust, the Gloria Ann Tillman Family Trust, and she transferred the house on Sycamore Lane into it. Not the deed, not the title. The house itself, transferred out of our joint tenancy and into the trust, with me as the lifetime beneficiary and trustee, and Michael as the successor trustee. The transfer was executed through a trust deed, not a quitclaim deed, not a warranty deed, but a trust deed, filed with the Spotsylvania County Clerk's office in February 2017 under a separate instrument number. Here's why this matters. When Gloria transferred the house into the irrevocable trust, the property was no longer owned by Arthur and Gloria Tillman. It was owned by the trust. When Gloria died in 2019, nothing changed. The house was already in the trust. It didn't pass through survivorship. It didn't pass through probate. It stayed in the trust, with me as the lifetime beneficiary. And when Lee signed the quitclaim deed in June 2024, she signed a document that transferred her interest in the property at 4012 Sycamore Lane. But she had no interest to transfer. The property didn't belong to me personally. It belonged to the trust. I was the beneficiary, not the owner. You can't quitclaim something you don't own. The deed was legally void from the moment it was signed. Gloria had built a firewall. 2 years before her cancer. 2 years before she knew she was dying. She'd looked at the future. At the possibility that someone would try to take the house, and she'd built a legal structure that made it impossible. Michael knew about the trust. He'd been the one who'd suggested it to Gloria. He'd reviewed the documents. He'd been named successor trustee specifically because Gloria trusted his legal judgment and his willingness to protect me. Dad, Brandon's eviction notice is based on a quitclaim deed that transfers a non-existent interest. Michael said, the property is in the trust. The quitclaim is void. The eviction has no legal standing. And here's the best part. By filing a fraudulent deed with the county clerk's office and serving you with a baseless eviction notice, Brandon and Lee have committed multiple violations of Virginia law. What violations? Filing a false lion or encumbrance, VA Code 551339. Attempted constructive fraud on an elderly person, triggering Virginia's elder financial exploitation statutes. Serving a fraudulent eviction notice, potentially actionable under both civil and criminal law. And if Brandon used his lottery winnings to fund the legal action knowing the deed was fraudulent, that's potentially wire fraud under 18 U. SC Section 1343. Al because of a quitclaim deed. Al because he didn't do a title search. Any first, your real estate attorney would have pulled the chain of title from the county recorder's office and seen that the property was transferred to the trust in 2017. The quitclaim deed Lee signed references a property that she has no legal connection to. Brandon's lawyer either didn't check or checked and didn't care. Either way, they're exposed. Michael filed a response to the eviction notice the next day. It was 9 pages long. It cited the trust deed, the irrevocable trust document, the chain of title from the Spotsylvania County Clerk's records, and the Virginia Uniform Trust Code provisions that govern trust property. He also filed a complaint alleging elder financial exploitation, fraudulent filing of a property document, and attempted constructive eviction. He attached my affidavit describing how Lee had brought the quitclaim deed to my home, described it as state planning, and had me sign it without disclosure that it would transfer a property interest. The counter-complaint named 3 defendants: Lee Marie Hale, Brandon James Hale, and the attorney who drafted and filed the eviction notice, a man named Craig Dunlap, who, Michael's research revealed, had been disciplined twice by the Virginia State Bar for filing frivolous actions and had a reputation for taking cases from newly wealthy clients who wanted to use the legal system as a weapon. Brandon received the counter-complaint on a Friday afternoon. Michael told me later that Brandon called Craig Dunlap in a panic. "They're saying the house is in a trust. Is that possible?" I didn't check for trust instruments. The deed search showed your wife's name. You didn't CK. I paid you $15,000, and you didn't check if the house was in a trust. Mr. Hale, trust transfers are filed under separate instrument numbers. They don't always appear in a standard title search unless you specifically do a your Joby. The irony of Brandon screaming at his lawyer for incompetence was not lost on me. Brandon had spent weeks researching Virginia property law on internet forums. He'd learned just enough to be dangerous and not enough to discover that the property he was trying to steal had been protected 7 years before he entered the family. The case moved fast. The Spotsylvania County General District Court dismissed Brandon's eviction petition in a 15-minute hearing. The judge, a woman named Patricia A's who'd handled hundreds of eviction cases, reviewed Michael's filing, confirmed the trust deed with the county clerk's records, and issued a ruling that was concise and devastating. The petitioner seeks to evict the respondent from a property that the petitioner does not own. The property at 4012 Sycamore Lane is held by the Gloria Ann Tillman Family Trust, an irrevocable trust established in 2017. The quitclaim deed filed by Lee Marie Hale in 2024 purports to transfer an interest in trust property, which is void as a matter of law. The eviction petition is dismissed with prejudice. The court further finds that the filing of this action may constitute a violation of Virginia Code Section 8.012-71(1), which prohibits frivolous filings, and refers the matter to the Spotsylvania County Commonwealth's attorney for review. Dismissed with prejudice. Meaning it can't be refiled. Meaning it's over. Meaning Brandon's the 15,000 lawyer and his 95 million lottery winnings couldn't buy him a house that a dental hygienist had protected with a first 200 trust document 7 years earlier. The criminal referral moved through the Commonwealth's attorney's office over the following months. The investigation focused on 3 areas: the fraudulent quitclaim deed, the elder financial exploitation, and Craig Dunlap's role in filing the eviction. Lee cooperated. That surprised me. Not because Lee is inherently cooperative, she's not, but because the alternative was criminal prosecution. Michael had made this clear in a conversation with Lee's lawyer. My sister can be a witness or she can be a defendant. She has 72 hours to decide. Lee chose witness. She provided a full statement describing how Brandon had researched quitclaim deeds, had coached her on what to say to me, had arranged the mobile notary, and had orchestrated the entire scheme months before the lottery win as a long-term strategy to acquire the property. He told me it was just estate planning. Lee said in her deposition. He said Dad would want me to have the house eventually, and this just made it official. I didn't understand what a quitclaim deed actually does. I trusted Brandon. Did you read the document before presenting it to your father? No. Brandon said it was straightforward. Did you know your mother had placed the house in a trust? No. I didn't know about the trust until Michael's filing. Did Brandon know? He never mentioned it. He said the deed search showed the house was in Dad's name. He said it was simple. The word Brandon used for everything he didn't understand. The legal system is simple. Property law is simple. Taking a house from a 67-year-old widower is simple. Everything is simple when you don't bother to learn how it actually works. Brandon was charged with filing a fraudulent property document, attempted elder financial exploitation, and conspiracy. Craig Dunlap was separately charged with filing a frivolous action and failure to perform due diligence. The Virginia State Bar also opened a disciplinary proceeding that would eventually result in his disbarment. The trial lasted 2 days. The prosecution's case was built on the documentary evidence, the trust deed from 2017, the void quitclaim deed from 2024, the eviction notice, and Leah's testimony describing Brandon's orchestration of the scheme. Michael testified as both a family member and an expert in Virginia real estate law. He walked the jury through the chain of title, explaining each document, each transfer, each legal principle. He explained how quitclaim deeds work, how irrevocable trusts work, how the Uniform Trust Code protects beneficiaries, and how Brandon's scheme failed because it was built on a foundation of legal ignorance. Mr. Hale attempted to use a quitclaim deed to acquire an interest in trust property. Michael told the jury, "This is the equivalent of trying to sell a car you don't own. The document is meaningless. The transfer is void, and the attempt to enforce it through an eviction notice, targeting a 67-year-old widower living alone in the home he built with his late wife, constitutes elder financial exploitation under Virginia law." Brandon's defense argued that he'd acted in good faith, that he'd relied on his attorney's advice, and that the quitclaim deed was a legitimate estate planning tool. The prosecutor dismantled this in cross-examination. "Mr. Hale, you testified that you researched Virginia property law before approaching your wife about the quitclaim deed. Is that correct?" "I looked some things up." "Yes. You visited 14 legal forums and websites over a period of 3 weeks in May and June of 2024. Your browser history shows searches for how to transfer property quitclaim deed Virginia. Can you evict someone from a quitclaim deed property? And how to take ownership of a family home. Does that sound like looking some things up?" "I was trying to understand the process." "You were trying to understand how to take your father-in-law's house. And at no point in your research did you search for property trust, or irrevocable trust, or trust deed. You didn't search for these terms because you didn't know they existed. And you didn't know they existed because you're not a lawyer. You're a former auto parts manager who watched a YouTube video about quitclaim deeds and decided you were an expert. That's not, Mr. Hale, after winning $95 million. The first thing you did was try to evict a 67-year-old man from his home. Not invest, not donate, not plan for the future. You hired a lawyer to remove your wife's father from the house he built with his own hands. Why?" Brandon didn't answer for a long time. Then he said something that the jury would later cite as the moment they made their decision. "Because I could." Because he could. 3 words. The entire philosophy of Brandon Hale, summarized in a sentence. He tried to take my house because he had the money, and he thought money was power, and power meant you could take whatever you wanted from whoever you wanted. The prosecutor paused. Let those 3 words sit in the courtroom. Then she turned to the jury. No further questions. Brandon's defense attorney attempted a redirect. He tried to reframe Brandon's answer as frustration, as a moment of emotional candor. But the damage was done. Because I could wasn't an answer. It was a confession. It was the worldview of a man who'd always measured his worth by what he could take from others, and who'd confused a lottery ticket with a license. The jury deliberated for 3 hours. During deliberation, they sent a note to the judge asking for the definition of constructive eviction under Virginia law. Judge Ames provided the legal definition from Virginia case law. Constructive eviction occurs when a property owner's actions make a dwelling uninhabitable or otherwise force a tenant to vacate. The jury noted that Brandon's actions, filing a fraudulent deed, serving an eviction notice, threatening sheriff removal, constituted a textbook case of attempted constructive eviction against an elderly homeowner. They also asked for the definition of undue influence. Under the Elder Financial Exploitation Statute, the judge explained that undue influence involves the use of a position of trust, authority, or emotional leverage to obtain an unfair advantage in a financial transaction, particularly when the victim is elderly, isolated, or grieving. The prosecutor had argued that Leah's visit with the quitclaim deed presenting a legal document as state planning to a grieving, isolated 66-year-old father met every criterion. He was wrong. Money isn't power. Knowledge is power. And Gloria Tillman, a dental hygienist from Fredericksburg who never earned more than $52,000 a year, had more knowledge, more foresight, and more power than Brandon Hale would ever accumulate. No matter how many millions he won, Brandon was found guilty on all counts. He was sentenced to 2 years of probation, 500 hours of community service, and $75,000 in restitution covering legal fees, emotional damages, and punitive penalties under the Elder Exploitation Statute. The $95 million, still his. The court couldn't touch the lottery winnings, they were legally obtained. But the judge added a condition to Brandon's probation that was, in my opinion, more devastating than any fine. Brandon was permanently barred from any legal or financial contact with me, my property, or the Gloria Ann Tillman Family Trust. He could not approach within 500 feet of 4012 Sycamore Lane. He could not contact me directly or through intermediaries. And he could not file any legal action involving my property or estate for the remainder of his life. A man worth $57 million after taxes, permanently barred from a $485,000 house. Because the house was protected by something money can't buy, a woman's foresight. Craig Dunlap was disbarred. The Virginia State Bar found that he'd failed to perform a basic title search, failed to verify the property's ownership structure, and filed an eviction action he knew or should have known was baseless. His law license was revoked. His malpractice insurance carrier settled a claim from Brandon for $180,000, which Brandon used to pay his own legal fees. The system eating itself. Leah and I had a conversation 3 weeks after the trial. She came to the house she'd tried to help take from me, the house her mother had built and protected and loved. She sat on the porch. I brought coffee. The dogwood trees Gloria had planted were in full bloom. Dad, I'm divorcing Brandon. Good. I signed those papers because he told me it was the right thing to do. I didn't understand what I was signing. I didn't know about Mom's trust. I didn't know what a quitclaim deed actually does. You should have asked me. I know. You should have asked Michael. I know. Your mother put this house in a trust because she was worried about exactly this. She told Helen Vasquez, our estate attorney, that she wanted the house protected from anyone who might try to take it from Arthur. Those were her exact words. Helen told me after the trial. She was talking about Brandon. She'd never met Brandon. She was talking about the future, about the possibility that someone, anyone, might see this house as an asset instead of a home. She didn't know who. She just prepared. Mom prepared for everything. She prepared for you, Leah. She loved you. But she knew that love doesn't prevent bad decisions. So she built a structure that would survive the bad decisions and protect the people she cared about. Leah cried. Not the tears of a woman performing grief. The tears of a woman who'd realized that her mother, dead 5 years, was still protecting her father from a porch she could no longer sit on, through a trust she'd filed with a county clerk 7 years before a lottery ticket changed everything. Today, it's been 4 months since the trial. The house on Sycamore Lane is mine. Not because the court gave it to me, because Gloria gave it to me in 2017. Through an irrevocable trust that cost $4,200 to create and protected $485,000 in property from a $995 million assault. Michael comes over every Saturday. He's teaching me about the trust, how it works, what it protects, how to maintain it. He's also helping me update it, adding provisions for the future that Gloria couldn't have anticipated. Not because I'm worried about Brandon, because I'm honoring the system Gloria built. She created a structure, I'm maintaining it. The way you maintain a house, brick by brick, room by room, with the steady attention of someone who understands that the things worth having are the things worth protecting. Brandon moved to Northern Virginia. He bought a house in McLean for $2 million. He and Lee are separated, divorce pending. The $95 million is being managed by a financial advisory firm that charges 1% annually, the $570,000 a year in management fees. Whether Brandon will have anything left in 10 years is an open question. Lottery winners, statistically, have a 70% chance of going bankrupt within 5 years, according to the National Endowment for Financial Education. Sudden wealth syndrome doesn't resolve with more money. It resolves with therapy, discipline, and the willingness to understand that wealth is a tool, not an identity. I'm Arthur Tillman. I'm 67 years old. My son-in-law won $95 million and tried to evict me from my own home. He hired a lawyer. He filed a fraudulent deed. He served me with an eviction notice, and he lost. Because my wife, a dental hygienist who never earned more than $52,000 a year, walked into a lawyer's office in 2017 and spent $200 on an irrevocable trust that was stronger than $95 million. Gloria knew. She always knew. Not because she could predict the future. Because she understood people. She understood that houses aren't just structures, they're targets. And the people who love you build walls. Not to keep people out, but to keep you safe. If you're watching this and you own property, especially if you're over 60, talk to an estate attorney about a trust. Not a quitclaim deed. Not a handshake. A trust. It's the difference between hoping your family will do the right thing and making sure it doesn't matter if they don't. Gloria taught me that. From beyond the grave, through a document filed at the Spotsylvania County Clerk's office in February 2017. Some women leave you recipes. Some leave you photographs. Gloria left me a firewall. And it held. If this story touched you, leave a comment. Tell me what you would have done if your son-in-law handed you an eviction notice. Share this with someone who needs to hear it. And subscribe for more stories about family truth and the documents that protect us when people won't. Before we close, this story, like all stories on this channel, contains fictional elements crafted for entertainment and educational purposes. If this type of content isn't for you, that's completely okay. Take care of yourselves. But if you stayed until the end, thank you. Gloria would have liked you. She always said the smartest people are the ones who plan for the worst and hope for the best. Now, if you'll excuse me, the dogwoods need watering. Gloria would never forgive me if I let them die.